Equal Employment Opportunity and Discrimination by Piotr Cieplak. Equal employment opportunity is an employment practice where employers do not engage in employment activities that are prohibited by law. It's illegal for employers to discriminate against an applicant or employee on the basis of race, age, color, sex, religion, and national origin. The overall policy objective for the employment discrimination laws we will be examining is summed up by the phrase equal opportunity. These laws generally do not aim to create equal outcomes, but rather seek to ensure that all employees or job applicants have an equal opportunity to engage in the employment market. In other words, these laws try to level the playing field, so that certain classes of people who have been discriminated against in the past are not subjected to adverse treatment based upon certain characteristics that have nothing to do with being a qualified job applicant or employee. The Equal Employment Opportunity Commission is an independent federal agency that promotes equal opportunity in employment through administrative and judicial enforcement of the federal civil rights laws and through education and technical assistance. Applicants and employees of most private employers, state and local governments, educational institutions, employment agencies, and labor organizations may be assisted by EEOC. The political system here in the United States, it has always been one of the most democratic systems in the world. There are a lot of civil rights that regulate the employment process by creating more opportunities for an equal employment for everyone, no matter their race, religion, nationality, age, etc. In theory, it seems like there is no way left for discrimination and there is an equal employment opportunity for everyone. But in real life, the things are different. Still, a lot of people think that they have been discriminated indirect during a job qualification process because of their race, nationality, gender, disability, etc. There are laws that prohibit that discrimination and give the people the right for an equal employment opportunity. The question is how these laws are interpreted or executed by employers, or how well the employees or potential employees know their civil rights that protect them. Sometimes these laws are misinterpreted, or even worse, not taken into consideration by the employer. Anti-discrimination law. The Title 7 of the Civil Rights Act of 1964 prohibits discrimination based on race, color, sex, religion, national origin, and retaliation. Equal Pay Act of 1963 protects men and women who perform substantially equal work from sex-based wage discrimination. The Age Discrimination in Employment Act of 1967 protects employees and jobs applicants who are 40 years of age or older from employment discrimination based on age. The Rehabilitation Act of 1973 applicable section prohibits discrimination in federal employment against qualified individuals with disabilities. Also requires employers to provide reasonable accommodation to qualified individuals with disabilities who are employees or applicants for employment. Civil Rights Act of 1991 provides right to a jury trial and monetary damages in cases of employment discrimination. No Fear Act. Case studies. Title 7. Title 7 of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. It generally applies to employers with 15 or more employees, including federal, state, and local governments. Title VII also applies to private and public colleges and universities, employment agencies, and labor organizations. Burlington Northern versus White. The facts. White, the only woman working in her department, operating a forklift at the Tennessee yard of Burlington. After she complained of sexual harassment, her immediate supervisor was disciplined. Thereafter, White was removed from forklift duty to less desirable, more dirtier duties as truck laborer, although her job classification remained the same. Further, she was suspended for 37 days without pay for alleged insubordination, but was eventually reinstated and given back pay in full. Burlington assessed that the White did not suffer an adverse employment action because she was not fired, demoted, denied promotion, or denied wages. The court held that White suffered retaliatory discrimination when she was reassigned to less desirable duties and suspended without pay. Although the duties were within the same job classification and pay was eventually reinstated, the actions were sufficient. The workplace harassment is any unwelcome verbal and physical conduct based on race, color, sex, regardless of whether it's sexual in nature or not, sexual orientation, national origin, age, disability, or retaliation that is so offensive as to alter the condition of the victim's employment. The conduct culminates in a tangible employment action, or the conduct is sufficiently severe or persuasive to create a hostile work environment, then this standard is met. Thank you very much for watching Equal Employment Opportunity and Discrimination by Piotr Cieplik.